All right, we're still in chapters 9 and 10. This is part 2 where we're going to be looking at security agreements. Still talking about ownership of property and the rights in property, and specifically real estate, the different interests that you can have. Looked at encumbrances and liens. And last time we learned about what a loan was, what made up a loan, a promissory note, talked about the security agreement briefly, and learned about default and foreclosure. Remember in the last section, we learned that if you don't have a pile of money to buy a house, that you can get a loan. And that when you get a loan, you sign a promissory note that says you're going to pay this money back over the next 15, 20, or 30 years. And you give the bank or the lender a lien on the property when you sign a security agreement, pledging the property as collateral to guarantee payment of the debt. So now we're going to take a closer look at the security agreements. Remember, a security agreement is a document that creates an interest in the real property and it guarantees performance of the obligation to pay back the debt. So depending on where you live in the United States, it's going to depend on which type of security agreement you're going to use. So one is called a mortgage, and the other is a deed of trust. So some states may use both, but most of the time states are going to use one or the other. Now these documents are pretty much identical in form and in substance. They serve the same purpose, they perform the same function. There are only a few slight differences, and we're going to talk about those. And one is very huge and important difference, which we're going to talk about later on in the slides. So depending on where you live, you're going to use one or the other. In Texas, we use the deed of trust. So when we talk about mortgages and deeds of trust, so it's mortgage, the term mortgage is sort of a generic term. And it just means that you've borrowed money, to pay for a house and you're paying it back over time, and the lender has a lien on your property. Because people in Texas, like I said, we use the deed of trust, but you don't necessarily use that term, deed of trust. So, some people say, oh man, my mortgage payment is so high, right? It's, $1,200 a month or $2,000 a month. Oh my goodness, my mortgage payment is out the roof. You don't say, oh, my deed of trust payment is sky high. You just say my mortgage payment, because that's what it means to borrow money against your house. It's the mortgage. So it's the document itself that has the title mortgage or deed of trust. Even if you sign a deed of trust, it's still a mortgaged property, but there's a key difference in the documents. So that's kind of what I want to point out, is that same function, just different title of document. So like I said, they're almost identical. They're very, very similar, except for a couple of key points. So both the mortgage and the deed of trust are going to require you to pay back the money that you borrowed, right? That they're going to provide for that provision, just like a promissory note, whereas the promissory note was the personal obligation and your personal promise to pay the money back. This mortgage or deed of trust, it's going to say, hey, you need to pay this money back, and you're putting up the property as collateral. Both of them say the property is going to secure the repayment of this debt. That's why it's called a security agreement, right? Because it's an agreement that secures repayment of the loan with collateral. They're both going to have provisions for default, right? So neither one of them want you to default, and they're going to have provisions that say if you default, what the consequences are. And one of those consequences of default is foreclosure. both the mortgage and the deed of trust, both are going to have a foreclosure provision. So something else both of the documents are going to have are things called performance obligations. All right, so these are things that the borrower must do, their requirements under the document, certain things they have to perform, right? So the performance obligations, and those are things like maintain insurance. So the bank wants the borrower to have insurance on the property, and that's in order for the bank to protect itself, right? Because let's say you don't have insurance on your home, and it burns down, there's no insurance to build a new home. Well, then the bank doesn't have its collateral is in ashes, right? The property is now worth much less, and the borrower has no incentive to repay the loan because he's not going to pay for a pile of ashes. So one of the provisions in the security agreement is going to say you must have insurance on this property. That way, if it burns down, you can get it replaced, and the bank still has security, and you still have a home borrower. And that may be just regular homeowners insurance. It may be flood insurance. It just depends on the jurisdiction and the location of the property and all of those things, right? So another one is to keep the property in good repair and condition. So the bank's going to say, you must keep this property up. You must keep this house looking nice. You must keep this building in good condition. Because again, the bank wants to protect itself. It wants to make sure that the property has value because that's their collateral. If you borrow $300,000 and then you let the property fall apart and it's only worth $200,000, well, then the bank isn't secure as much as it was when the property was worth $300,000. So the bank wants to make sure that you keep the property in good repair. That way, the property value stays, high, or at least relative to what you borrowed. And another one, both of the documents and mortgage and deed of trust is going to have is to pay all of the taxes and assessments on the property due. So remember last week when we talked about the ad valorem taxes, those are the property taxes that are due every year, right? Remember our guy with the $11 million home and he had to pay $200,000. He has to pay that every year. And his mortgage, if he has one, is going to tell him that he needs to pay those taxes every year on time because the tax jurisdiction, the taxing authority can foreclose for non-payment of taxes. And the tax lien is always superior, is always first. And if the tax authority forecloses, then everybody else gets wiped out and loses. So again, the bank, to protect itself, is going to say, you must pay these taxes on time, because if not, then they're going to end up in foreclosure and the bank's in jeopardy. The same thing with homeowners association, the assessments. Those can also jeopardize, a mortgage, and they're going to be a requirement to pay those. So they're going to say, anytime there's money due on this house, whether it be a tax or assessment, don't let any liens get on this house. And if you do, we have a problem. So, right, if you don't have insurance, don't keep the property in good repair, if you don't pay your taxes, all those things are obligations, which means you must do them. They're in a contract. You must do these things. If you don't, then you're in default. And once you go into default, that means you're subject to foreclosure. So both the mortgage and the deed of trust have the same type of stuff in the documents, right? They have the same requirements of the borrower. They're basically identical. But there are some differences. And they are key differences. So first we're going to take a look at the mortgage. So the mortgage, the document mortgage, is a two-party instrument. So the borrower and the lender. The borrower is called the mortgagor. This is the one who has ownership in the property and puts it up for collateral. And the other party is the mortgagee. This is the one that receives the mortgage. And once again, you'll remember our old friends EE and OR, right? The mortgagor is giving, the mortgagee is receiving the mortgage. The deed of trust, on the other hand, is a three-party instrument. You still have the borrower and the lender, right? The borrower and the bank, known as the beneficiary in this case, and this guy we call the trustee that holds the property in trust while the debt is outstanding. So the mortgage, it has the default provisions, right? If you don't pay money back, if you don't get insurance, if you don't pay your taxes, if you don't fulfill any of your, certain ones of your obligations, you're in default. That default can lead to foreclosure. So foreclosure is really where the difference is in these documents, right? So this is what sets the mortgage and the deed of trust apart, is the foreclosure proceedings. So with a mortgage, you have to do judicial foreclosure. And that's just like the name says, judicial, right? So you think of a judge and a court and the legal system. So the judicial foreclosure requires the bank to file a lawsuit against the buyer and get a judgment against them before they can foreclose. So it's a very long process. There's lots of steps. And then you have to give notice. Then you have to file a lawsuit. Then you have to get the judgment. Then you have to get permission to sell. Then you can finally sell. Long, long process, and costly. In fact, Black's Law Dictionary says it is a costly and time-consuming foreclosure method by which the mortgage property is sold through a court proceeding requiring many standard legal steps such as filing of a complaint, service of process, notice, and hearing. So again, this thing can take, best case scenario, 6 months, worst case scenario, years and years. The judicial process is slow and painful and costly. So that's what happens with a mortgage. That's the way you gotta go in the states that only do mortgage. With a deed of trust, though, still have the same thing, right? You still have all the same default provisions. If you don't do this, if you don't do that, you're in default. You can result in foreclosure. Except the foreclosure proceedings used for a deed of trust is called non-judicial. And just like it sounds, there is no court involvement. Very streamlined process. Basically just give notice and then you can sell the property. And that's because in the deed of trust, the borrower grants a power. Oh, it's not a very good R, is it? And power of sale. So these are magic words. Power of sale. So in the document, the deed of trust document itself, these three words are in a provision, and it says the borrower hereby grants the lender a power of sale on the property. And that means that they have already given their permission to sell the property in order to satisfy the debt. So if you don't pay the debt, or if you default under the mortgage, the deed of trust, the bank can sell the property and you've given your permission. So very streamlined process. You can have this done in 90 days in some cases, but very, very quickly because all the steps have been taken out of it, right? You just say, hey, you sign the document, you give us power of sale, you don't pay, we can auction your property. Very streamlined. So this is Black's definition of it, foreclosure process by which, according to the mortgage instrument and state statute, the property is sold at a non-judicial public sale by a public official, the mortgagee, or the trustee in most cases, without the stringent notice requirements, burdens, or delays of judicial foreclosure. So it's very quick, it's much, much cheaper, and a lot easier process than the judicial way. All right, so that's it. So you need to know the two types of security agreements, mortgage and a deed of trust, know the parties of the documents, and definitely know the difference between judicial and non-judicial